Evening, everyone. On behalf of the Free Library of Philadelphia and the Social Science and History Department, let me welcome you to this evening's program. Without further ado, I'm going to introduce you to our host for this evening, Debbie Gross, who's President and CEO of Pennsylvanians for Modern Courts, who comes to Pennsylvania for Modern Courts for 35 years of private legal practice in federal state courts all over the country, concentrating on complex commercial litigation. She was Chancellor of the Philadelphia Bar Association in 2017, also serving as the president of the Philadelphia Bar Foundation in 2013 and 2014, and as a trustee of the foundation from 2004 to 2020. She's also served on the Bar's Foundation's fundraising committee, grants committee, finance committee, and development the Cypress committee. She served on many boards before coming to Pennsylvanians for Modern Courts. Okay, without further ado, I'll introduce you to Debbie.
Hi, and thank you so very much for having us, Maria. We love our partnership with the Philadelphia Free Library. I have joining me a lawyer who I used to go up against all the time, so I love it. I have Mark Sonnenfeld joining me, who is a partner at Morgan Lewis, has been a part, is one of the longest tenured partners at Morgan Lewis, and was a frequent strong litigant opponent, and who has been in courts across the country and has had many renowned cases that he has taken to trial. Unlike me, I will tell you, after 35 years of practice in federal and state courts, I've actually never had a trial, which is pretty amazing. So we're here to talk about threats to Pennsylvania's judiciary and the judicial system in general. And so I wanted to say thank you, welcome. This will be recorded. We have this program as well as many other programs on PMC's website that you can listen to. I really enjoy this program. It's one of my favorites, and I do hope you enjoy it too. I've brought it current. It goes into many different aspects. So thanks, Maria. And you want to next slide. So a little bit about first. This is our, if you could scan this QR code and answer questions, because we need statistics and information for our funders. So put your phone up to the QR code, scan it, and give us information. You'll have another opportunity at the end. So thank you. Next slide. So a little bit about PMC. We were established actually 35 years ago to support the creation of merit selection in Pennsylvania. As you will hear, we elect our judges in Pennsylvania, and that is really not a good thing. But I say that also at a time when we have judicial elections on the ballot in November. So while we support in Pennsylvania merit selection, which means that judges would be selected or appointed and not elected, since we have judicial elections, go out and vote. It's an off year, right? It's an odd number year, so not that many people show up to vote, but if we're going to elect judges, please come out. Only 20% of Pennsylvania's voting population, I'll say, comes out in odd number years, and we really need to improve that. We do not want the minority making decisions for the majority. The right to vote is really important. Next slide. So what Pennsylvanians for Modern Courts does, we do a lot of different things. In addition to supporting merit selection, we also support judicial conduct reforms. We also support reforms of the court, modernization of the court. We now go into schools and teach about the court system and topics, and legal topics and judicial topics. We have coming up on October 24th, and I think it probably is the next slide, so I could be jumping ahead, an appellate court candidate forum. And this is a slide of all of our upcoming programs. As you see, we do a lot of education programming. So we will be making this PowerPoint available after the program. The library will send it to you. But any of our programs that are virtual, no matter what the location is, you can join us. So please feel free. Next slide. Okay, so first, a little bit about, since we're talking about threats to the judiciary, right? Let's talk about, put it in context. And so, the judiciary is our third branch of government, and there's meant to be checks and balances, and we need an independent judiciary in order to balance out the executive branch, legislative branches, which have each their own responsibilities. So, executive branch is, we all know it as the president, but also in Pennsylvania, it's our governor, or in the city, it's our mayor. So they have certain job responsibilities, but and then we have the legislature, which we have a federal Senate and House, and we have a state Senate and House. And in Philadelphia, we have a city council. So they make the laws. We'll hear how sometimes these other branches threaten the independence of our judiciary because of the interaction or interrelationship between the three branches. Next slide. So we always like to start with this quote from James Madison, the Federalist Papers, but there's a reason why this country was established with three branches of government, because we do not want, all power in one of our branches, right? We want that checks and balances. It's really important. Thanks. Next slide.
Let me chime in here.
Sorry.
Let me chime in here before we start talking about the Pennsylvania judiciary. I think it's helpful to distinguish it from the federal judiciary.
Mhm.
And as Debbie said, we have three branches of our federal government: the executive, which is the president, the legislative, which is Congress, the House of Representatives and the Senate, and the judiciary, the Supreme Court. Then there are 11 intermediate appellate courts, and then there are district courts, one or more for each state. In the federal system, judges are appointed by the president on the advice and consent of the Senate, which means that the presidential appointment must be confirmed by the Senate to take office. Once confirmed, a judge serves for life in good behavior. A judge may on occasion be impeached, but that is very rare. Federal judges, unlike Pennsylvania judges, serve for life. And in the Federalist Papers, where Hamilton and John Jay and Madison explained why the Constitution was written as it was, they talked about lifetime tenure being very important for judicial independence. And the Federalist Paper number 78 talks about the importance of lifetime tenure to assure judicial independence. And that is in contrast to the Pennsylvania system, whereas we'll discuss shortly, unlike the federal system, judges are elected to serve 10-year terms, and they're elected in partisan political elections. And we'll talk more about that as we move along. But that's an important distinction between the federal system and the state system.
Thanks, Mike. So the next slide discusses where the powers for our judiciary come from, and that's our Pennsylvania Constitution, which is a little piece of information. The Pennsylvania Constitution is actually older than the U.S. Constitution, and our court system is actually the oldest court system in the country. So, we have a lot of history in Pennsylvania. And as we said, like the Article 2 gives the legislative power to the General Assembly. Article 4 gives the governor our supreme executive power. And Article 5 creates this unified judicial system, which has expanded, I'll say, since the Constitution was first established. So we have 3 appellate courts that were not initially contemplated, but because of how busy our court system was, our appellate courts have expanded. Is there anything you want
Well, I'd like to just add, because Debbie raised a very important point on the history. The Supreme Court of Pennsylvania traces its history to 1722, which means if we do our arithmetic correctly, the Pennsylvania Supreme Court celebrated its 300th anniversary last year in 2022, and it claims to be the oldest appellate court in America. There were some predecessor courts that served the function until 1722, but in 1722, what is now the Pennsylvania Supreme Court was organized and continued to be organized. And the Supreme Court of Pennsylvania sits in Harrisburg, the state capital, as well as in Philadelphia and in Pittsburgh. In colonial times, the Supreme Court of Pennsylvania sat here in Philadelphia in what today we call the Independence Hall. And there was a room there where the Supreme Court of Pennsylvania sat. And July 4th, 1776, the date of the Declaration of Independence, where the Supreme Court sat, they took down the picture of the crown and replaced it with the seal of the Commonwealth of Pennsylvania. So that's important. Now, Pennsylvania, unlike the federal system, has had several constitutions, and we now operate under the Constitution of 1968. And we've had several constitutions, in between, but the basic structure remains the same, tweaked as we have grown and added courts, and we'll talk about that more.
Great, thank you. Maria, next slide. So I wanted to just generally discuss what a judge's responsibilities are, because, we all see judges on television and we all have our own opinions on how a judge should act and decide. But, it's really important for a judge to remain neutral and impartial and independent, right? They should make their decisions based on facts that are presented before them, as well as the law, not only the Constitution, but statutes, but cases. They shouldn't favor one party or another. They are asked frequently to make a determination as to whether some law is constitutional or unconstitutional. If there is some kind of conflict the judge may have, the judge should recuse themselves, to avoid any kind of appearance of impropriety. And judges cannot comment on cases that are currently before them. There are in Pennsylvania, there's a code of conduct that the judges have to abide by. There is a judicial conduct board where people can file complaints if they feel a judge is not following a code of conduct or treating them fairly or properly. Mark, do you have anything to add?
Well, I think this might be a good point to add how we select our judges in Pennsylvania. As I alluded before, in contrast to the federal system, where judges are appointed by the president and confirmed by the United States Senate, in Pennsylvania, we elect our judges in partisan political elections. They run in the primary to get the nomination of a party, and then the party's candidates compete in the general election in the fall. We elect our judges for 10-year terms in these partisan political elections. And then at the end of a 10-year term, a judge can stand for retention for an additional 10 years. The retention elections are nonpartisan. The judge doesn't run against an opponent. Simply the candidates are on the ballot with the questions put to the voters. Should Judge Gross be retained for an additional 10-year term? Yes or no? And in the history of the present Constitution of Pennsylvania, I think there's only one occasion when a judge for an appellate court was not retained, and there have only been a handful of cases when judges of lower courts have not been retained. We also in Pennsylvania, unlike the federal system, have an age limit. And the age limit had been 70, and now the age limit has been raised to 75. And the Constitution of Pennsylvania provides that a judge can't remain in office after the end of the calendar year in which he or she attains the age of 75 now. So that is important. Since our judges run for election rather than appointment by the executive, our judges have to campaign for office, and they have to raise money. And there are limited sources for money, but this is we'll discuss this as a potential jeopardy to independence. But the judges do have to raise money, and under our Pennsylvania system, there is no limit to how much a a judge can raise or from whom the judge can raise the money. As a practical matter, there are limited numbers of potential sources of fundraising for judicial candidates. But that also is an important distinction between the Pennsylvania and federal system. And when there is a vacancy in the judicial office that ultimately has to be filled by election, the governor does have the power to make an interim appointment until the next election. But the interim appointment has to be confirmed by, I believe it's 2/3 of the Senate. That's a pretty high bar. So there can be a vacancy filled by appointment, but it's only until the next election.
And so, for example, currently there's only 6 Supreme Court justices on the Pennsylvania Supreme Court. And so the governor did not make an appointment because it's a 7-person court to fill that empty seat, but we will in November be electing that 7th justice for the Pennsylvania Supreme Court.
This also might be a good point, just to interject a little on the structure of our courts. We have in Pennsylvania 3 statewide courts. We have, of course, the Supreme Court of Pennsylvania, which consists, as Debbie said, of 7 justices, and that sits at the top of what we call our unified judicial system. And we have 7 justices elected. Right now, we have 6 sitting, and we have 1 vacancy. And then we have 2 intermediate appellate courts with statewide jurisdiction. One is the Superior Court, which consists of, I believe, 15 judges elected statewide. And the Superior Court, as a general proposition, handles appeals from the courts of common pleas, and its decisions may be subject to further appeal to the Supreme Court of Pennsylvania. And the other court of statewide jurisdiction is the Commonwealth Court. And this is a court of 9 judges, also statewide jurisdiction. And it is a interesting innovation of the Constitution of 1968. And to try to oversimplify it, the Commonwealth Court, for the most part, handles appeals from state agencies. For example, if you have a workers' compensation claim and it goes before the Workers' Compensation Board, the appeal would go to the Commonwealth Court. If there is an election dispute and the Secretary of State has ruled one way and a candidate wants to challenge that, that would go to the Commonwealth Court. If you have a matter before the Public Utility Commission involving an electric company rate, if either side is dissatisfied with the Public Utility Commission's ruling, that can be appealed to the Commonwealth Court. So it is a very important court. The Commonwealth Court now has 1 vacancy out of the 9. And I believe the Superior Court may have 2 vacancies. Another thing that is, I think, very interesting is how the electoral system has worked and what it has produced. And our Supreme Court of Pennsylvania now, of the 6 justices, is evenly divided between men and women. We have 3 men and 3 women. And in the candidates likely to survive the primary for the general election, we may have 1 male and 1 female running for Supreme Court. So the gender of the majority of the Supreme Court will be determined by the election in November. And on the Commonwealth Court, right now, of the 8 sitting on the court, 7 are women, and 1 is a man. And on the, so and again, the 2 candidates that are running, 1 is a man, 1 is a woman. And the Superior Court, there are two vacancies, and most of the judges elected who are sitting on the court now are women on the Superior Court. So that is an interesting development of relatively recent years. Another thing I find is interesting is, and we'll talk more about this, is of the 7 justices on the Supreme Court, or actually 6, there's 1 vacancy. right now. 4 are from Philadelphia or Pittsburgh, and 2 are from elsewhere in the state. But it's just the opposite on the Commonwealth and the Superior Courts. And this has been the result of our elections. And we'll talk more about that. But I think both of those facts are interesting.
There was one question which I just wanted to address. So that, as Mark said, the age limit had changed from 70 to 75. It occurred through a constitutional amendment. And so in Pennsylvania, and we'll sort of touch upon this in a little bit, but a constitutional amendment has to be passed by 2 legislative sessions, the same exact wording. There has to be notice. Then it is put on the ballot and the voters have to approve. So typically in Pennsylvania, voters approve constitutional amendments. I'll say something that's not really, it's somewhat, I'll say the constitutional amendment about the age limitation was a little confusing. The wording was confusing.
Yes.
It said, would you like to extend the age limit to 75?
Yeah.
Right? Or it said, we would like to, as opposed to saying, we already have an age limit of 70 in Pennsylvania, and should it be extended to 75? So wording is a whole, as we all know, but words are important, especially for lawyers. And the constitutional amendment that was proposed was definitely a little.
It was not artfully drafted.
Thank you.
And I guess while we're on that subject, we should mention that of the 6 justices now sitting on the Supreme Court of Pennsylvania, 4 are Democrats, or were Democrats when they were elected. They ran as Democrats, 2 ran as Republicans. But on the Commonwealth and Superior Court, it's just the opposite. And there are more Republicans than Democrats sitting on that off. Why, I don't know, but that is what the election system has produced. And I would say this. If there's one takeaway you get from the hour of listening to Debbie and me today, if there's one takeaway that we would hope you would remember, is that in the election coming up in November, only a month away, there is a vacancy on the Supreme Court of Pennsylvania. There is a vacancy on the Commonwealth Court of Pennsylvania, and there are 2 vacancies on the Superior Court of Pennsylvania. And we have both noticed that more often than not, these vacancies and the elections to fill them are totally ignored by the press. You hear very little about them, but they are really important. And we would urge you to try to familiarize yourself with the candidates for these judicial vacancies. I also say that the bottom of the trial court level of the system, Pennsylvania system, are the courts of common pleas. And there is a court of common pleas for each county. Some courts of common pleas may cover a judicial district that encompasses more than one county. And those judges also are elected for 10-year terms and can serve until they can be retained until they reach the age of 75.
So I'm going to add 3 points and then we'll move on. But one is that there's also elections in November for municipal court judges and magisterial district court judges, depending on where you live. Municipal court judges are only in Philadelphia. Outside of Philadelphia, in every other county, they're magisterial district court judges. And I know Mark was pointing out the makeup of the courts, but it's also important to know that we have the first female president judge of our Supreme Court. Chief Justice for the first time in 300 plus years, which is also pretty remarkable and wonderful. So those are my little additions, and let's continue on because we're not going to get through everything. So, this is a brief, synopsis, outline, however you want to say it, of what we hope to convey to you. But there are many different threats to the judiciary's independence. There's security, right? There's physical threats to the judges and their family and their clerks. There's legislative actions, right? We talked about the 3 branches of government. There's statutes or proposed constitutional amendments. There's misinformation and disinformation about the court system. There are elections, and there is unfortunately decreasing confidence in the judiciary. So if we have anything that as a takeaway, one is, first, judges are really important to the survival of our democracy. And I truly believe that. And so your vote does count. I mean, there is there's a retired Superior Court justice who was elected. The difference was 13 votes. So she likes to say every vote counts, and it really is important. Okay, next slide. So we'll briefly discuss security because it's really relevant. Next slide. So there's both physical and verbal threats. So, you know, and I tried to bring this current because we all need to know about this. You know, the former president was sitting at trial, and while he was in the trial, he, you know, tweeted out something, and that wasn't the first tweet that he's mentioned, you know, attacking the judge's clerks and the judge's family. So he did it while he was sitting in the courtroom. So the judge in his case imposed a gag order about the attacks on the judge's aides and clerks and, you know, assistants, because it's dangerous. It's just there's no ifs, ands, or buts. The other, next slide, the other threat is that there are actual physical threats. So, you know, just recently there was, you know, a New Jersey man who had, I think it's literally yesterday, who was indicted on, you know, harassing judges and public officials in the Garden State. You know, there's also been, next slide, a judge in New Jersey, a federal court judge in New Jersey, who was unfortunately, I'll say, greeted by an attorney who was unhappy, displeased, found her address and came to her house and with a gun, and unfortunately and horrifically killed her son. And she has been, you know, on a campaign to protect the judge's personal addresses so that they don't have people coming to their house. In New Jersey, it was passed. It's called Daniel's Law. There was a similar proposal in the federal government, which has been signed by President Biden, but is being challenged in court as to its constitutionality. So, you know, and in Pennsylvania, we actually passed a law last year that the goal was to remove the addresses of the judges so that people wouldn't show up at their house with guns. But as you know, it's really hard to pull back information once it's been on the internet.
Well, and this is a real change in our society. 50 years ago, I was a law clerk for a federal judge in the federal courthouse, then located at 9th and Chestnut Streets here in Philadelphia, and there was zero security. You could walk in the bazooka on your back and nobody would stop you. The judge's chambers weren't locked. The courtrooms weren't locked. And I'm not aware of any problems that occurred in the time that I was there. And up until quite recently, City Hall here in Philadelphia, which houses our state courts, had virtually no security. Anybody could walk in and get pretty close, but that has changed. And it's a societal problem that affects the executive and legislative branches as well. But judges are uniquely vulnerable. Yesterday in Wisconsin, a man who had been arrested for coming to see the governor with a gun and was let out on bail, returned this time with an AR-15 and was arrested again. So
and it used to be that judges got extra security when they had a controversial case or a mafia kind of case, but now, you know, extra security is not unusual. And the courts actually have what's known as incident reports, and they're in the thousands. So it's really a serious concern. Next slide. So this was the bill that was signed into law by the president. It was called the Supreme Court Police Parity Act, which is interesting because it was limited to providing protection for the Supreme Court, right? And any member of their immediate family. But it's a step, I'll say. It didn't expand to all the courts. Next step, next slide. So besides the physical and verbal threats, which we all like, which are obvious and really upsetting, we also have legislative actions that threaten the independence of our judiciary. And so, for example, the legislature controls the budget process, right? Both Congress as well as our Pennsylvania House and Senate in the budget process make a determination as to how much money should be given to run the court system. So the court system in Pennsylvania, the Administrative Office of Pennsylvania Courts prepares a budget, makes a presentation to, well, used to actually the Chief Justice used to go into Harrisburg and make a presentation. Hasn't happened in recent times, but they present a budget, and sometimes it is approved by the legislature and sometimes it is not. There have been times in the past that the legislature has decided to punish the courts for decisions that it has made and has decided to decrease that year's budget. It shouldn't be, but therefore the court doesn't lay off judges. What impact is on sometimes technology or sometimes assistance for those who are filing cases. Do you have anything to comment on?
The only thing I'd add is another source of another issue is judicial compensation. And for a judge, the compensation set by the legislature is much less than a qualified lawyer would be able to make in private practice. So this limits the pool of people who will seek judicial office. It limits to people who are either independently wealthy or who have made a career of public service or who are prepared to make a greater sacrifice than society has a right to ask of them. And it means going back to the legislature for funding. We had a situation in Pennsylvania several years ago. I mentioned once an appellate judge lost for retention. What happened that year was the legislature had raised the salaries of all of the officers in the state, the governor, the legislators, and the judges, and there was a taxpayer revolt. And the only statewide election that year was for Supreme Court of Pennsylvania. And as a way of taking out their anger, there was an organized effort for voters to vote no. And a justice of the Supreme Court who was up for retention, who had nothing to do with the pay raise and who had done a very good job as justice, got defeated in the retention election that year.
So as we always say, the purse strings, right, are controlled by one branch, unfortunately, and it can impact the independence of the judiciary.
And let me just say why that was important for independence, because it might not be immediately obvious. I know I'm taking time, but judges running for retention, if they had kept their nose clean and behaved properly in the past, could always count on getting retained. And they didn't really have to campaign. They didn't have to curry the support of political leaders. They didn't really have to raise money. But when this justice was not retained because of things having nothing to do with the justice, for every judge or justice now up for retention, they now have to have the concern of will they be retained, which means they A, have to raise money, and B, have to curry the favor of political leaders. And failing that, they put in jeopardy their retention, which really works against judicial independence.
Okay, next slide. So not only are there budgetary threats that are imposed by the legislature, but the legislature has the power to impeach. And so there have been threats in our state based on certain rulings by our judges that the legislature is going to impeach. But the most recent, so this is why I brought this slide forward, is the situation that's going on in Wisconsin, because the Wisconsin Supreme Court election this past April, changed the political majority composition on the court for the first time in many years. The Wisconsin Supreme Court justice did campaign on an abortion topic, was a Democrat. And so the governor and the House and Senate in Wisconsin are Republican. And before this justice even took the bench, there were threats that they would impeach her. So there were even complaints before she even took the bench. There were complaints filed with the Wisconsin Judicial Commission that she had violated the ethics rules by her campaigning. The Judicial Commission has dismissed those complaints, but there are still talks about possible impeachment proceedings.
And we've had that here in Pennsylvania several years ago, when the Supreme Court of Pennsylvania set aside the congressional districts that had been set by the legislature as being violative of the free and equal provision of the Pennsylvania Constitution. There were legislators who were so upset about that they threatened to impeach the justices who had voted to set aside those congressional districts.
So, okay, next slide. No, keep going. Next slide. Sorry. You're not going to get stuck on that. So we've discussed the legislative methods, I'll say, of impeachment, but there's also, the legislature could pass statutes. The legislature could propose constitutional amendments. And as we discussed, constitutional amendments, while they are not easy to pass, because they require, the being passed by two legislative sessions, same wording, it requires notice, and then it requires the voters to approve it. They don't get voted down. Although I should say, when we'll discuss this, there was one recent constitutional amendment that there's a number that have not occurred, a few that have not been supported, but there are statutes, and nevertheless, there's still statutes and constitutional amendments that are out there, that have been out there, that are toyed with based on, I'll say, threats to the judiciary based on decisions. So they are out there. I like to say there's something always hanging over the judiciary, that there are these threats, and the judiciary has to ignore them in order to be this independent third branch of government. Next slide. And so I like to bring this current, so Montana is a prime example. It just passed a law that abolished the state's judicial nominating committee and just gave the governor unfettered powers to fill judicial vacancies. So, there's still, if there's an opening, there's no vetting through a judicial nomination committee now, and it is up to the governor in between elections. So, that was one way to try to make an appointment more political. Next slide. But as we briefly talked about how the Constitution can be amended, but the U.S. Constitution is a much more difficult process, but the Pennsylvania Constitution is actually not that difficult process, because it's not something that can be vetoed by the governor. And so if depending on the makeup of the House and Senate, it could be pushed through in a very expedited fashion. Once it is defeated, then it cannot reappear for 5 years, I'll say. Next slide. So these are some examples of, this is an example of a constitutional amendment that was defeated in Pennsylvania. It was known as House Bill 38, or previously House Bill 196. And it was a proposal to change the way we elect our appellate court judges in Pennsylvania. And it too came about because of a decision rendered by our Pennsylvania Supreme Court on the voting redistricting issue. So there was a proposal that instead of statewide election, of judges for the appellate courts, it would be divided into districts. So there was a lot of organized calls to the legislature, and it did not pass through the second reiteration, I'll say the second session of the legislature. But it was going to be on there. There was a serious chance that it would have made it as a constitutional amendment to be voted on by the voters, but because of the groundswell from voters, it did not make it. Next slide.
Well, let me
Okay.
just stick with that, because I
Okay.
think that was very important. And that was a very dangerous opportunity for mischief in the process.
Mhm.
And here is why, in no particular reason. If you set up judicial districts for the Supreme Court justices and the judges of the Superior and Commonwealth courts, you've created a whole nother layer of gerrymandering. And if we can't even agree on neutral lines for congressional districts and state legislature districts, how are we ever going to agree upon how to structure the districts for the appellate courts? So that is one problem it creates. Another problem, and I think this is what was aimed at and was very sinister. At the time House Bill 38 was proposed, there were 4 justices from Allegheny County, all 4 of whom had voted to jettison the redistricting plan. And what the amendment provided was that the legislature could set the ground rules for retention amendments. And basically what it would have meant is that for the 4 justices from Allegheny County, 3 of them at the expiration of their terms would not have been eligible to run for retention. So that would have accomplished the goal of certain legislators to throw off the court the justices who had voted for redistricting, because 3 of them wouldn't have been eligible to run for retention since there already was a sitting justice from Allegheny County. Another reason why this is a bad thing is that what appellate courts do is really deal with the law, which should be uniform throughout the Commonwealth and not by districts. And for the most part, the Commonwealth and the Superior Courts sit in 3-judge panels. Right now, you may sit in a 3-judge panel, but all 3 judges will have been elected statewide. If you had judges elected to these courts by district, then one panel could have 3 Allegheny County judges, another could have none. Another one could have 3 from Philadelphia. So how you would balance the panels, I think, is an issue that nobody thought of. And another issue is the parties come from different counties. If you are from Bucks County and your opponents from Delaware County and the whole panel is from Delaware County, how are you going to feel about that? So if the parties are from counties, you have one party is from a county of the judge on the court and another is not, that really encroaches upon the perception of fairness for the process. So those are among the reasons why House Bill 38 was, in my opinion, a very bad idea.
I mean, but the other interesting thing is that, with my merit selection hat on, right?
Yeah.
We want, there is this opposition to merit selection because you want the voters to speak. Yet by dividing the elections into districts, people would be voting only for one judge every, I think it was like 18 or 20 years or something. So that it's not something that we're not giving the voters a voice.
Yes.
So next slide. So these are a few examples of bills that were proposed as well, as a result of, like, they were created to try to rein in the judiciary, right? So which and some of them may have some points that are good, but the reason that they came about was, I would say, not out of good. So elimination of retention elections of judges. Okay, so retention elections, not a partisan process. what it's requiring here is that it would be, fully contested partisan elections every 10 years. It means our judges would be campaigning a lot. But it also means that our judges would really have to be careful of which decisions they authored. And there's a former Chief Justice of our court who says there would be a lot of swapping. Who would write the decision? It would be some, who's up for election, and maybe we'll pass it off. So that the retention, by getting rid of retention elections, the judges would have to be running every 10 years. Take some time. Our appellate court judges, for example, are generalists. They're not specialists. They have to learn all areas of law. And, sometimes by the time that it takes a little while to understand all the areas of law that our court rules on.
Yeah, elimination of retention elections is a very bad idea because it would force judges into the partisan process after they're already on the bench. It would then detract from their independence and their decision making. It would also force them to have to raise money, and it would force them to have to curry the favor of political leaders.
Next slide. Oh, keep going. Next slide. Sorry. That was just to discuss. So another is term limits on appellate court judges. Again, I'm not saying the concept's, a bad concept, but it should have, there should have been a process that this is through which this is discussed, and maybe I'll say a resolution that would make more sense would come about. So, it limits appellate court judges to 2 10-year terms. Is that right? I mean, should they be 18-year terms? I mean, we should have a more comprehensive analysis, I'll say, but, limiting a judge to 2 10-year terms, again, that may discourage qualified candidates because they're leaving the legal profession, becoming a judge, then have to come back into the legal profession or into some other profession. So, will this hamper the administration of justice? Our judges not only are judges who listen to cases, but also sit on rules committees, procedure committees, rules of evidence committees, help determine rules of conduct for the judiciary, help determine I'll say rules of conduct for lawyers. So there's a lot that our judges do that we don't know.
This takes us back to where Pennsylvania was before the Constitution of 1968, when I believe the Supreme Court justices then were elected for a single 21-year term. And that got changed and puts us back. But to get into 10-year terms, that's a really short term for an appellate judge to serve.
Okay, next slide. Next slide. So I think it's the last amendment I'm going to really spend some time on, but it talks about like how the rulemaking of this one would propose to limit the judges' rulemaking authority. Right now, our Supreme Court Pennsylvania Supreme Court, you should know, has the ultimate rulemaking authority on changes to our criminal court rules, our civil court rules, our family court rules, our rules of evidence. This proposed constitutional amendment would would change it to have the legislature have this power. Now, the federal system is very different. There's the Rules Enabling Act, and there is a process. The legislature does have some authority in the rulemaking, in the judicial rulemaking, but there was no support for how this was to occur in Pennsylvania, and it again was a constitutional amendment that wasn't very clear. Next slide.
Well, let me just add another amendment that may be related to this that died in the legislature, but I thought really had a great potential for mischief. And that was an amendment that was proposed to give the Auditor General, who is an elected official, the power to audit all election results in Pennsylvania, subject to guidelines to be set by the General Assembly. And the effect of that amendment would have been to take the courts out of the line of decision-making on election challenges. Because now for a statewide office, the Secretary of State certifies the results, and that can be appealed to the courts. But under this proposed amendment that fortunately died, the Auditor General would have had control subject to the legislature setting guidelines. So that I thought was a very dangerous proposal.
Thank you.
And it shows why
about that.
we have to be on guard here.
Okay, we're going to skip the other proposed amendments. None of these came to fruition, I will say, which is a good thing, but that they do sneak up on you and because of like sometimes they just pop up after a Supreme Court's decision, which is crazy.
Well, you remember the old saying that after the constitutional amendment, Constitutional Convention met, a lady on the street asked Ben Franklin, well, what have you produced? And he said, a republic if you can keep it.
Right.
And that if you can keep it requires eternal vigilance now, even 250 years later.
Yeah. So another threat to judicial independence is misinformation and disinformation, right? So, judges they can issue decisions, right? They're very lengthy decisions. Sometimes they're not always understood, or they're in the middle of a trial, but when they're in the middle of a trial, they have a code of conduct. So they can't address matters that are currently before them. They can't really defend themselves. That's why a lot of bar associations will step up to the plate and defend some attacks on judges. The code of conduct in Pennsylvania forbids a judge to speak and say anything that would impact their impartiality on a matter, that would give an appearance of impropriety. They can't, for judicial elections, for example, candidates cannot say how they would rule as a judge on a case that would be in front of them. However, recently, I guess it's 20 years ago, but there's been some change, I guess, expansion of the interpretation. The ABA model code of judicial conduct prohibited candidates from judicial office from announcing their views on political and legal issues ahead of an election. The Supreme Court in 2002 said that provision was a violation of freedom of speech of our First Amendment rights, of the judges' First Amendment rights. So, does that decision, I'll say, impact a state's an interpretation of a state's judicial code of conduct? There's a lot of discussion about that, but I just wanted to let you know that was out there. But again, judges issue decisions, issue opinions, and they can't talk about them. They can't. They're supposed to put in the opinion, right, why they came to this decision, but they don't get out there and have a platform and explain how they came about. Next slide. There's one judge who talks about how we should write a summary in this day and age, because now judges issue decisions. For example, a Commonwealth Court judge recently issued an 800-page decision about the constitutionality of education funding in Pennsylvania. But one judge said we should be issuing now, a synopsis in the beginning, similar to what the U.S. Supreme Court does, because people don't read an entire decision. They're lengthy to understand. They contain some legalese. And so let's help make it, let's simplify it and have an explanation up front of our position and our finding and our conclusion. Not all judges agree with that. I mean, Mark, I don't know what you think about that, but sometimes the length of the decision prevents somebody from understanding and prevents it being covered in the proper fashion by the media.
Some judges write well and some do not. Some decisions are very ponderous, others are very carefully written. But that's not a criteria for electing judges, unfortunately.
Right. Okay, next slide. So also there's just a general misunderstanding, right, about the court system. I mean, there's currently a case in New York, and what's being brought across the news is, why is there not a jury trial? What happened? Why was the president denied a jury trial? Well, it was because their counsel didn't ask for a jury trial. So, you have to, as a plaintiff in a case, if you're filing, in a civil action, like, ask for a jury trial. It's a little box that you check off. Or sometimes you may decide, as the case progresses, the parties may decide that they don't want a jury trial, and both parties agree to proceed as a bench trial before a judge. But there's just a general misunderstanding about the court system. People don't want to sit as jurors, and you know what? It's really important for people to sit as jurors. You want a jury of your peer. You want to make sure that our justice system continues. So there are people don't understand the impact of the judicial system and think that judges should just make a decision based on, their own personal opinion as opposed to interpretation of the law. There's many different, misunderstandings that are out there about the court system. Okay, and I know we're running out of time. And next slide. We have like 4 minutes less. We only hit. It's a good thing we did this. Judicial elections. We did talk a lot about them, but next slide. Judicial elections require raising vast sums of money, and so and as Mark said, like, who's going to contribute to judicial campaigns? If sometimes if you're an individual, you don't really think the court system is going to have that much of an impact on you. Well, unfortunately, frequently the largest contributors to judicial campaigns are attorneys and litigants, and parties of interest, right? So that's not a good situation. There's, I won't go into it, but there's a famous Supreme Court case about, a judge who was elected based through the support of fundraising from a litigant, and once that judge was elected, the case end result was changed and actually went up to the U.S. Supreme Court. So, money is dangerous. The judge, does a litigant go in front of that judge and say, well, I made this contribution to your campaign? I mean, it gives an impression that the judge may not treat both parties equally. Okay. Anything else? Because I know we're running out of time. We have like 3 minutes left.
No, I'll yield my time to you, Debbie.
Okay, and our last slide is that unfortunately, poll after poll recently has been showing that there's decreasing, public confidence in the judiciary, and it's based on, what's out in the news. Unfortunately, Pew Research recently did a 2023 study about the favorable or unfavorable views of our U.S. Supreme Court, because our U.S. Supreme Court is now in the news, but there's other courts that are, I like to say, just as important as our U.S. Supreme Court. Our U.S. Supreme Court only issues, a limited number of decisions a year, but that's what's covered. And I will say that our U.S. Supreme Court doesn't have a judicial code of conduct, which is a big controversy now. Whereas in our state, our Pennsylvania Supreme Court does have a judicial code of conduct. So I know we are like at 7. Mark, do you have anything to add? That I've rushed through the end of this?
No, I think you've covered it all and covered it well.
So I want to thank the Philly Free Library for having us. I looked through the chat. I believe I hit all the questions. I know there was a question about whether we keep statistics on recusals, and I honestly don't have the answer for that, but I will look into it and try to find the answer. My gut impression is that the AOPC, the Administrative Office of the Pennsylvania Courts, does not have those statistics, but I'm going to look and see if what the answer is for that question.
I do know the Supreme Court of Pennsylvania will, before arguments, notify each side of any contributions the other side
Right.
had made. I had a case when I saw what mine were compared to the others, I thought I really was a biker. And tell you what, I thought a funny story. A friend of mine one night invited me to a fundraiser for a certain judge running for appellate office and that he was holding. I said, I really feel awkward going to that because I have a case before that judge. And he said, I'll call you back. He called me back about an hour later. And he said, and he mentioned the judge by name, said, it's okay for you to come. And I said, what? You called the judge and asked him? And he said, well, don't you want to know why the judge said it's okay for you to come? So I said, okay, why did he say it's okay for me to come to your fundraiser for him? And he said, because your opponent came to a fundraiser for him the night before. So I think that says it all about why we need to change.
But we shouldn't be having parties that are litigating in front of a court attending fundraisers for that court. I mean, there can be, there are many education programs where lawyers and judges are in the same room. They can have conversations, that's fine, but contributing to judicial campaigns, that's dangerous. So again, thank you for having us. Thank you, Philadelphia Free Library. Thank you, Maria, so very much. And we look forward to future programs. I know there's another one in November, but there's also before the next program, the October 24th Appellate Court Candidate Forum sponsored by PMC. So go online, www.pmconline.org and register. Thank you very much. Bye.
Thank you.